Okay. Hello, everyone. Hopefully you can hear us. Thank you for joining us today for today's webinar. So my name is Beth King, and I'm the Marketing Director at Margolis & Bloom. And Margolis & Bloom works with its clients to find the best estate planning or elder law solution for each client's unique situation and goals. We bring to this effort 30-plus years of experience and a commitment to providing the highest level of personalized service. So today's presentation is by Harry Margolis and Tricia D'Agostino. We'll call her Tricia in here. And it's a deeper understanding into the new Secure Act and how it may affect you. If you have questions during the presentation, there's a question panel on the right side of your computer, and we will make time for questions at the end. And if we don't get to them, we'll make sure to follow up for those of you who have been on other webinars first. We do promise to follow up. So with that, I want to turn it over to our presenters, and Annie, take it away.
Okay, hello everybody. Welcome to the Secure Act, and we're hoping you're going to feel very secure by the time we're done. So this is just an overview of what we're going to talk about. The old rules, we'll just review those. We'll explain the most important new rules. We'll talk about if you're probating the estate of somebody who died last year, that there's an important thing you can do that might make sense. Then we'll talk about planning for minors, family protection trust, special needs trust, and then we actually have added a couple of case studies that might help make the rules a little more understandable in terms of how they really act. And then we'll have, as Beth said, we'll have some time for questions and answers at the end. So let's get into it. So we can close that panel there. There you go. Okay. So as you probably know, under the old rules, the required beginning date to take minimum distributions was the year after you reached age 70 and a half. If you inherited an IRA from someone else, you could stretch out the withdrawals over your lifetime based on your own life expectancy. So for the inherited IRAs, you couldn't wait to 70 and a half. You had to start the year after you inherited the IRA. Spouses could convert their own IRA to, their inherited IRA to their own IRA, so they could then delay withdrawals to age 70 and a half. And if you had no designated person or no one qualified as a designated individual as the beneficiary, you had 5 years after inheriting the IRA to withdraw all the funds. So some of these rules still stand, but basically the main one that still stands is in terms of spouses. There's no change for them. But the basic new rules are that the required beginning date has been pushed back to age 72, so people can hold off. For inherited IRAs, if you were, then backwards on the 72 and the date there. So for inherited IRAs, you can no longer use your life expectancy. There's now a 10-year rule. But I believe that the June 30th, 1949, I think that actually applies. I think we put that in the wrong place. I apologize for that. That actually applies to the required beginning date after age 72. So if you're born on July 1st, 1949 or later, you can postpone withdrawals to age 72 if you choose. But for inherited IRAs, you don't fall under an exception, which we'll go over. You only have 10 years to take out the money. There are exceptions. And another change is there used to be a limit on contributing to the IRA after age 70. So if you're still working, under the old rules, if you had a 401k plan, you could keep contributing to it. But if you had an IRA, you couldn't. Now you can keep contributing to an IRA as well. So the exceptions to the 10-year rule. Spouses, as you said before, there's no change on rules with respect to spouses. Individuals who are disabled, permanently disabled, or chronically ill can also continue to use the old life expectancy tables and are not subject to the 10-year rule. Those who are less than 10 years younger than the deceased person from whom they inherited the IRA, they can also use the old stretch schedules. And then minors, it's a little more complicated. So if a minor inherits an IRA, they can use their own life expectancy withdrawals until they reach the age of majority in their state. So in most states that's 18. So until age 18, and then the 10-year rule applies. So basically they use their own life expectancy until they're age 18, and then they got 10 years to withdraw the rest of age 28. However, if they're still in school, and we'll have to see some kind of definitions coming out about how you prove these things, but if you're still in school, you can postpone, you can continue to use the old life expectancy tables up until age 26, and then the 10 years apply. So for those who are going to school, they may be able to get up to age 36. But of course, that's a lot. They may be losing more money in tuition than they're gaining in tax savings. So those are the basic new rules. So I want to spend a few minutes talking about a planning technique that may be going away, or will be going away pretty soon. So if, say you have a situation where a person dies, they have a surviving spouse, and the surviving spouse can take the IRA, transform it into his own IRA, and use his own life expectancy. But when he dies, whatever's left in the IRA, if he's going to pass that on to his kids, they're going to be subject to the 10-year rule. Now, if the kids had inherited the IRA in 2019, then they could use their own life expectancy tables and not be subject to the 10-year rule. And so the kids may be worse off under the new rule because they're going to have accelerated withdrawals. But it's possible still to claim the old life expectancy tables for withdrawals if the parent in that situation disclaims, because then the money goes directly to the child, and it will be deemed, if the disclaimer is done in time, will be deemed to have inherited it in 2019 upon the death of the parent. So hopefully, I don't know if that makes sense to anybody who's listening, but maybe this example, which happened in our office, will help. So our client died in May of last year. She left $1 million, more or less, to her husband. That included a $300,000 IRA. So if we did nothing, the husband would get the $300,000. He would spend it down based on his life expectancy, and hopefully he'll live a long time, so there wouldn't be that much of the IRA going to his daughter. In this case, they only have one child, and it might not be too much of an effect. But he doesn't live a long time, and he dies, say, in a year or two. Most of the $300,000 will go to his daughter, who will have to withdraw it during the next 10 years, when she and her husband are fortunately in pretty high earning capacity, so probably at a pretty high tax rate. So what they did is the husband filed a disclaimer. So the father/husband filed a disclaimer, so that the IRA is now going directly to the daughter. It's an inherited IRA for her. Since her mother died in 2019, she's subject to the old rules, and she can stretch out the withdrawals over her life expectancy, and she doesn't have to withdraw very much each year given her age. Of course, so I think that was actually our next slide. We left something on. Beth is going to fix our slides in front of us. So the one thing to know about this, next one.
Okay.
There. Okay, so this is what we did. But the one thing I want to add here is the last bullet point there is it's a disappearing option because you can only disclaim during the 9 months, within 9 months of the date of death. So as each month goes by, there are fewer estates that you can disclaim, and so that's an issue. So if someone dies, say, I have to do the math here quickly, but if someone died on September 1st, then you have until June 1st to do the disclaimer, and if someone died October 1st, you have to July 1st. But you have to do it within 9 months. So eventually, as we go, when we get to September 1st of this year, it'll be too late to use this option for anybody. So if you're listening and it applies to you, move fast. So now I'm going to turn this over to Tricia, who is going to talk about trust for minors.
Okay, thanks. So as Harry said earlier, minors are an exception to the rules, so they're what's called an eligible designated beneficiary, and they can use their life expectancy to make withdrawals of the retirement account. The issue is that typically we don't want to leave assets outright to minors because we need trust to manage the assets for them. They can't control the assets themselves. It might result in a conservatorship. And so what we typically do is leave the asset in trust with a family member or a friend managing the trust for the minors. So what we need to do is figure out how we can maintain the life expectancy withdrawal under the Secure Act for minor beneficiaries. So I thought just briefly I'd go through what the situation was with trust before the Secure Act. So before the Secure Act, we had two options. We could use a conduit trust, which would require that all the withdrawals, including the RMDs, would be distributed out to the beneficiary. And if that was the case, then the life expectancy of the beneficiary could be used, the life expectancy of the minor. Another option was an accumulation trust. This trust allowed the trustee to hold the withdrawals from the retirement account in trust, so it didn't require them to be distributed. But all the beneficiaries had to be identifiable. You could not have a charterless beneficiary, and in this case, the life expectancy of the oldest potential trust beneficiary was used. So it might not have been the minor's age if there was somebody who was maybe a remainder beneficiary that was older than that minor who could have received after the minor's passing, that trust beneficiary's lifetime would be used. Now, after the Secure Act, we can still use a conduit and an accumulation trust based on the client's different views and objectives. So with the conduit trust, it will qualify as an eligible designated beneficiary and allows the trustee to withdraw the account over the minor's life expectancy until they reach the age of majority, as Harry said, and then they're subject to the 10-year rule after that. But it still requires that all distributions from the retirement account have to be distributed to the child. So that's a careful consideration that you have to make with clients because depending on the size of the retirement account, we don't necessarily want to be requiring the trustee to distribute all those assets out to the child or to be used for the benefit. We also still can use an accumulation trust, and this would qualify as a designated beneficiary if it meets the other requirements of for being a seeking trust, meaning still no more charities, all the beneficiaries have to be identifiable, and if that's the case, then you can use the 10-year rule to withdraw the account. The benefit, I guess, in this case is that there is no more age restriction on these trusts. So if you have a remainder beneficiary that might be the person's parents, for example, or their sister or sibling that could be older than their minor child, it's no longer an issue. But you do still have to make sure that there are no charities listed there. So I just listed here a couple of questions that we sort of are thinking about with our clients in terms of deciding to decide what do we do? Do we do an accumulation trust or do we do a conduit trust? And what we look at is how big is the retirement asset? Depending on the size of it, do we care about whether or not the trustee has to distribute everything that's withdrawn from the retirement account out to the beneficiary or use for the benefit? Or is it really important to the client that the trustee is able to maintain the flexibility where they can use the money that they withdraw at their discretion, so they don't necessarily have to distribute it out and they can hold those funds in trust? Also, it's important to determine whether or not a charity is going to be a contingent beneficiary. So if a family, for example, has a minor child and no other children and no other family members or friends that they want to leave assets to, they may want to name a charity as a remainder beneficiary. And if that's the case, they would have to stick to a conduit trust, because you cannot do that with the accumulation unless they wanted to use the accumulation and lose the 10-year opportunity and just go back to the 5-year rule. So that is it on minors. And Harry's going to talk now about family protection trust.
And I would just add, Tricia, with respect to the minors trust, the parents may also choose to either have a trust that doesn't qualify either as a conduit or as an accumulation trust, because maybe they want to include charities or some other reason like that, and so they may decide, or it's a very small IRA, so it's kind of not worth the trouble of just having it go straight out to the kids. So of course, if they're minors, you're probably less likely to want to do that. So I'm going to talk about family protection trusts, which are related to minors trusts, except they continue for life. And so a lot of our clients provide for their kids through trusts, and the trusts are written in a way that they're very protective of what the children inherit. So if the children are go bankrupt or get sued for any reason, the funds in the trust are protected. In some cases, for people with more money, the trust can offer some estate tax reductions or eliminations. There's divorce protection. If the child gets divorced, the funds in the trust will not be included in the split of the couple's assets. It preserves the assets for future generations, since the funds are held in trust and they won't go to a surviving spouse who may get married to somebody else who knows where the funds will go. They can stay in the family. And also, sometimes it's important to have perpetual management of the funds, and the trust provides for that as well. So, under the Secure Act, when we had IRA or retirement plan money going to family protection trusts, we pretty much always used conduit trusts. So, because and conduit trusts, as Tricia explained, the income, the required minimum distributions have to be distributed out. But we figured that was fine. Those were going to be based on the children's life expectancy. They're not going to be that great. And it's certainly easier to manage everything in conduit trusts. So we would generally have the funds go out, and there was no issue with that. The beneficiaries could be engaged, and ultimately the money, if that's what the family wanted, could go to charities or somebody to be named later. But that's not necessarily, that doesn't necessarily work anymore, because now, rather than the RMDs coming out over the child, the beneficiary's life expectancy, they all have to be withdrawn and distributed with 10 years if it's a conduit trust. And there's a little bit of confusion, at least in our trust and probably other lawyers' trusts, because the language in our trust talks about the required minimum distributions, and there are no more required minimum distributions. So I think it would be interpreted to mean that everything has to come out over 10 years, and it's up to the trustee to determine when and how during those 10 years. But it's an issue. So what do you do? So and it depends on the situation and every client's goals. So if the IRA is relatively small, I probably wouldn't make any changes. So it's got to be distributed within 10 years. It's probably not a big deal. Leave it as it is. Also, if you don't really care whether it's a smaller IRA and you don't care whether the kids get it directly, and you're not so worried about making sure they don't withdraw it, since it's going to have to be withdrawn over 10 years anyway, then maybe just bypass the trust. It might be simpler for everybody if the funds go directly to the kids and you don't even use the trust for this purpose. So that can be a good solution. You could also revise the trust so it is an accumulation trust so that the RMDs don't have to be, well, there are no more RMDs, but so that the IRA funds that are withdrawn during the 10 years don't have to be distributed out. So that it has the benefit of protecting the funds, which is the purpose of the Family Protection Trust in the first place, but it may have some drawbacks. One is that if you had charities as subsequent beneficiaries down the road, for instance, as a fail-safe that everybody in the family would pass away, you couldn't do that anymore in an accumulation trust. But another probably more important issue with these trusts, especially if it's a larger IRA, is that there potentially be higher taxes. So on the IRA withdrawals, because trusts have a more accelerated tax schedule with a trust income reaching a higher tax rate much more quickly than individuals. So unless the beneficiaries themselves are in a high tax bracket, having the funds stay in trust and tax at the trust tax rate rather than being distributed out and taxed at the beneficiary's tax rate can end up in higher taxes. So this is going to depend on the amount that's in the IRAs, so how much income there's going to be over the 10 years, and also on the income tax bracket of the beneficiaries, whether you're going to be better off or worse off. Another choice is to use a non-qualified trust. So it doesn't have to be a conduit or an accumulation trust. It could be a trust that is basically an accumulation trust, but we're not worried about who the ultimate beneficiaries are going to be. So that makes it easier because the trust can say anything you want. You don't have to qualify as a designated beneficiary. But you could run into more severe tax issues here, depending on how big the IRA is, because instead of being able to divide the trust withdrawals into 10 shares, you're dividing into 5 shares. Well, I should say something about that. I say it's 10 years or 5 years in terms of withdrawals. It's really 11 or 6 years because it's 5 full years after the person passes away, or 10 full years after the person passes away. You can take a withdrawal if you want to divide everything evenly, you can take a withdrawal before the end of the year during which they passed away, plus 10 more or plus 5 more. So you can kind of keep taxes down a bit by doing that, by spreading out the withdrawals. So just to summarize, if you have a plan with Family Protection Trust, you're probably going to want to take a look at it, and depending upon the size of the IRA, the situation with your kids, and what the tax consequences might be, you may want to make a change, or you may want to leave it as it is, especially if it's just a smaller IRA. So another kind of family protection trust is a specialized one for children or others with special needs and the need to stay qualified for public benefits. And Tricia will talk about that.
Okay. All right. So as Harry mentioned earlier, disabled and chronically ill individuals are also an exception, and they're treated as eligible designated beneficiaries, which means that they can withdraw the after of their life expectancy. We're still waiting on information. It'll be more clearly defined in the regulations in terms of who will determine if the person is disabled or chronically ill. Under the current regulations, the disability determination is similar to what would be used for eligibility for SSI and SSDI, and chronically ill is similar to what would be used for someone who's trying to get coverage under long-term care insurance. So things like assistance with activities of daily living, but those types of certifications and who will make those decisions will still be up for determination under the regulation. And as Harry mentioned earlier too, the disability must be intended to be permanent. So it's not meant for temporary disability. And so for estate planning, often we're using trust to receive the inheritance for an individual with disabilities because we want to maintain that person's eligibility for public benefits. So in the past, before the Secure Act, we primarily used an accumulation trust because we do not want a conduit trust, which would require that all the withdrawals be distributed out to the individual. We wanted to give the trustee the opportunity to decide when it was appropriate to use discretion to make distributions. And the life expectancy of the oldest potential trust beneficiary was used. So we were concerned with who remainder beneficiaries were and what the difference in age was between that person and the current beneficiary. And we were also concerned with making sure there were no charitable remainder beneficiaries. Now, after the Secure Act, we're still able to use accumulation trust, and it has been a carve-out in the Secure Act, which is helpful for folks with disabilities and who are chronically ill, because it allows us to use an accumulation trust and still use the disabled person's life expectancy. So it's different from the situation with minors, where we can only use their life expectancy till age of majority, and then the 10-year rule applies. Here you have the life expectancy of the disabled person's life regardless. And we don't necessarily care about who the remainder beneficiaries are in terms of how old they are. They can be older because under the rules, we're not concerned with the measuring life anymore. It's just the disabled person's life expectancy. But there are a couple requirements, and one is that it be for the sole beneficiary of the disabled person during their lifetime. And that's something I know that we've been reviewing in our trust, and you should have your trust reviewed for as well, because there are provisions in special needs trusts often that say things like the trustee is permitted to use trust assets for the beneficiary's descendants in the trustee's discretion, or the trustee can use trust assets to pay for housing even if it benefits others, or the trustee can terminate the trust based on XYZ reason and distribute the assets to someone other than the beneficiary. So I think it's important to have special needs trusts reviewed to make sure if they are going to be receiving retirement benefits, none of those provisions are in there, and the trust is in fact just for the sole benefit of the beneficiary. And you still cannot have charitable beneficiaries. So when I said we don't care necessarily about the remainder beneficiaries, I mean we don't care if we have older potential beneficiaries than the disabled person, but we still care if they're charities. So if there's a charity, it will not qualify as a C3 trust. Another requirement for special needs trust is if, under the multi-beneficiary rule, is if you name a revocable trust, for example, as a beneficiary of your retirement account, that then says the trust divides into 3 shares, 1 for my disabled child and 2 for my 2 non-disabled children. Since that division occurs immediately upon the account owner's death, so upon death it divides into 3 shares and is distributed to a special needs trust and my son John and my daughter Jane, that would still allow the special needs trust to use the disabled person's life expectancy. So it would have to immediately divide upon the death of the owner.
So Tricia, can I ask a question? What happens if you have an IRA that goes into a trust for a spouse, and then at the spouse's death it divides that way?
I would think.
Maybe in that case, to make sure it works, you have to convert it to the spouse's IRA.
What I've read so far is that I think you would be able to use the eligible designated beneficiary's life expectancy so long it was in a trust that was for their sole benefit. And that's what you're saying?
Well, it's for the wife,
first.
Spouse first, right.
But then to SMP.
Okay.
So far, that's what people are saying they think will happen.
Okay.
But I don't know for sure.
So another thing with these, which may be reverse of sometimes advice we might have given in the past, is often if a client's had a number of children, one of them has special needs, they might, rather than just dividing everything equally, they might, including the retirement plans, we often advise, well, it might be easier just not to have the retirement plans go to the special needs trust, have that go to your children without special needs, and then in the trust we don't have to worry about any of these issues. And that's been kind of an easier way to manage things often. But that also potentially means higher taxes now, because the non-special needs children now are going to have to withdraw all those funds over 10 years, and they may be earning a lot of money over the next 10 years, following 10 years after the client's death. But if the money went to the special needs trust, and it qualified as it should, then you could use the child with special needs, his or her life expectancy, and potentially substantially lower the tax consequences of the withdrawals. So may want to reverse the plan depending on the size of the IRA and how big an impact this might have.
Mm-hmm. The other thing I did mention, which is just that if the trust is taking withdrawals over the disabled person's life expectancy and then that person passes away, then the 10-year rule applies to the remainder beneficiaries. Okay, so I think now we're on to the case studies, and you are going to talk about the first one, Harry.
Yes. So we have these, I don't know if we're going to get through all the case studies, but we'll see how fast we go before we have some time for questions. So we have a couple. They have about $300,000 in IRAs, about $700,000 in other investments, and a house with a value of about $800,000. We're assuming for this no mortgage, not that it probably affect this planning. They have 3 adult children, and they created conduit family protection trusts for the children. So they say that to the extent that the IRAs are in the trust, that they're going to distribute out the RMDs directly to the children. So this is a kind of case where it's relatively small IRAs. Well, let me step back. What we don't say is how old they are. So one question is, are they in their 50s, and this IRA is going to start getting a lot larger over the next 10, 20 years of their work lives, or are they in their 70s and the IRA is going to start getting a little smaller as they withdraw. So the latter case is the easier one. So I was about to say that the IRAs aren't huge. It's a relatively small percentage of their estates. It's going to get smaller over time. I think they could either just leave the plan as it is, or change the IRA beneficiaries directly to the kids after each other. So that's pretty simple. But if they're younger, and these are likely to grow significantly over the next 10 or 20 years, then they might really want to think about changing the plan and having either having the family protection trust. I mean, you can still leave it as is, figure 10 years is fine in terms of the withdrawals, or they could turn these into accumulation trusts so that the IRAs can be protected entirely when they pass away. And that's really this case. So now we have the same couple, but their investment picture is kind of reversed. They have most of their investments in retirement plans. So this is a case where they might not want the conduit family protection trust because they have $300,000 going into trust for each of the children, all going to have to be drawn over 10 years, distributed out, and basically that's a pretty good part of each child's inheritance that ultimately won't have the protection of the family protection trust. We talked about all the creditor protection, divorce protection, so death protection, all the protections it provides will not apply to the inherited IRAs. So this couple with the larger IRAs may be more interested in considering the accumulation trusts, basically changing the trust terms. But but they also need to consider the tax consequences of doing so, because they're still going to have to withdraw the funds over 10, 11 years. They just won't have to distribute them. And the issue there is now we're going to have these funds remaining in trust, and or the income on them remaining in trust and being taxed at the trust tax rate. Now at $30,000, I didn't look that up, but it's probably not at the highest trust tax bracket, but it still may be a higher tax bracket than the kids, depending on how much income they're earning. So this gets to be a harder issue in a longer discussion.
Okay. All right, so the next one I'll do, this one, the couple has $400,000 in IRAs, $200,000 in investments, and $800,000 house. they have 3 minor children, and they already have conduit family protection trust for the kids. So in this case, I think that there is probably not much that will change for that family. So if the account owners name each other as primary beneficiary of their IRAs, with the trust for their kids as the contingent beneficiaries, upon the death of the survivor, essentially it would pass into the conduit trust for the kids, and if the children were minors, they would be able to use their life expectancy to the age of majority in order to withdraw the accounts. The conduit version of the trust, as we mentioned a few times, would require that any withdrawals from that account, including the required distributions, would have to be paid out to the children. But since it's $400,000, it's probably, the trustee could probably find something to use that money for each year for the benefit of the child. If they were
since they're pretty young, the withdrawals are going to be pretty small.
Right, exactly, right. So, so I think in this case, just making sure that the account owners name the trust as the contingent beneficiary, I would feel comfortable with that.
Let me ask you a question. So I wrote this up and I said conduit, but in most cases this would probably have been an accumulation trust.
Right.
So you were saying with the special needs trust that there's kind of a safe harbor for the accumulation trust in terms of the other the remainder beneficiaries?
Right, so here,
is this too?
well, no, so there's no safe harbor here. So if you are if this was an accumulation trust instead and didn't require that the distributions be paid out to the children, and the account owner died while the children were still minors, they would have to take the funds over the 10-year period instead of using the life expectancy. So the trustee would be subject to the 10-year rule instead of life expectancy the age of majority.
Uh-huh.
So if the account was larger and they didn't want to require that the distributions be made payable to the child, they may be faced with losing the life expectancy option to the age of majority and losing that period of tax deferral, whether it be to 18 or 26, as we said earlier. Okay, so this one, the fourth case study is, there's a couple, again, the $400,000 in IRAs, $200,000 in investments, and a house, and there's 3 minor children, and one has special needs. They already have a trust with an accumulation special needs trust to be funded when the youngest child turns 25. So this is a common type of just joint revocable trust that says upon our passing, it can stay in trust for our kids' benefit and the trustee's discretion until they turn 25, at which time the trust has to terminate. And 1/3 goes to the special needs trust for John, 1/3 goes to Tricia, and 1/3 goes to Beth. So what happens in this case? So if the account owner died before the youngest child turned 25, then they would be subject to withdrawing this over the 10-year rule. And that's because basically, with regard to special needs trust, special disabled beneficiary, in order for them to qualify as an eligible designated beneficiary, they can be and to get that deferral over their life expectancy for the accumulation trust, the trust can only be for their sole benefit. So if the trust is still in a pot trust until they're 25, it's benefiting other people other than the disabled person.
What if they're all still minors?
So, and if they're all still minors, you also are subject to the 10-year rule because it's an accumulation trust.
Mm-hmm.
So what I would probably do is, instead of, I probably wouldn't have a pot trust in a trust that's going to be receiving retirement benefits. Instead, do a trust that says upon the death of the owner, so it divides immediately upon the death. It goes, 2 shares can still stay in a continuing family trust, which just gives the trustee discretion to distribute at age 30 and age 35, or in whatever in the trustee's discretion at any time, and then can decide whether or not to make that accumulation or conduit based on the size of the assets and the age of the kids. And then 1/3 goes to the special needs trust, with the disabled beneficiary being the sole beneficiary, so that you don't jeopardize, at least don't jeopardize the disabled person's life expectancy, because that's over their entire life they can withdraw that account, and then decide whether or not you're going to make the family fund trust, so to speak, a conduit or accumulation.
So really separate out at day one the funds going to the special needs trust.
Right. And I think the other thing I haven't mentioned here, but I did put on one of the slides and I meant to bring up, but just in terms of beneficiary designations, I think are going to be important as well with this. So we're talking a lot with clients about these different questions depending on the size of the assets and what's important to them, and we're tweaking the trust to work. But I think we also need to make sure we're working with clients to complete beneficiary designations appropriately. So if a conduit trust is named, we name that trust so it's clear that that trust is the beneficiary for a special needs trust.
So it's saying, would this apply, say, for spousal cases where because I said nothing changed for a spouse because the spousal marital trusts are conduit trusts, but formally the beneficiary designation could say to my trust, and it would go into the marital trust. Now, do you have to actually designate the marital section of the trust?
Right, because if you just say the Tricia D'Agostino Family Trust, how does it could be potentially going into a family trust instead of a marital trust. So you want to make sure you're specifically naming the conduit trust as the beneficiary designation.
So even with spouses, though they don't need to change their documents, they should change their or potentially should change their beneficiary designations.
Right.
Okay.
Okay. So I think that is it.
Except for the questions.
Yes, for the questions and answers. So let's go and check out what we have. Okay. 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 In 2019, in order of the 2019 estate scenario, but if surviving spouse already claims the descendant's IRA, then it's too late to disclaim.
Right, that's a good point. So when I was talking about a potential disclaimer for people who have passed away towards the end of 2019, so the money can go rather than to a spouse, go to the kids, you can only do a disclaimer if you haven't already benefited from the asset that's being disclaimed. So if the surviving spouse has already taken some money out from that IRA, it's too late. So you can't take advantage of that little planning idea.
Okay. So special needs question. Could the ABLE account of an SSI recipient, developmentally disabled adult, be the beneficiary of a 403B and take distributions over his lifetime?
So accounts aren't beneficiaries. So trusts are beneficiaries, individuals are beneficiaries, but bank accounts, an ABLE account is really a type of bank account, are not. So it would have to be so yes, I can see the question because you want the funds to go straight to the ABLE account, not go to the beneficiary because they'd be counted as belonging to the beneficiary and disqualifying them from SSI. So I think I don't know anything about that. And the question would be, could you have an inherited IRA held by an ABLE account? That might be what it is. So if you got an inherited IRA, could you then transfer it into an ABLE account so it would not be a countable asset for SSI purposes? I haven't heard anything about that. So probably not, but maybe that's something that we made to happen.
Okay. Are the non-spousal inherited Roth IRA rules for distributions the same as a regular inherited IRA, IRAs?
For that.
Don't.
To be honest, I and maybe Tricia as well are not real experts on Roths. So I don't think there's a whole lot of changes with Roths, but that'll have to be maybe we'll have to research and write a blog about that.
Okay. So we set up a special needs trust for our son, and court granted us guardianship, but he was denied SSI or SSDI. What does this mean?
Oh, I think that's probably unrelated to this. So probably we should talk about that separately. If you want to send me an email at hsm@margolis.com, where we can try to figure out why that was.
Okay. If special needs trust allows distributions for expenses of an essential support person, i.e. admission fees, activity equipment, while supporting the person who has a disability, does that undo sole benefit status of trust?
That's a good question, because you can always make payments on behalf of the person, of the beneficiary, and that's not going to be a problem. Depends if it's how specific it is. What do you think?
I think the same thing. So they're saying, this one I think the equipment payment for whatever the individual needs is for their benefit. I wasn't sure if this was getting at the question of paying for like a travel companion type of.
Yeah, I think it's probably okay. I think it's probably okay, because I think those are all for the person's benefit rather than making somebody else a beneficiary. Like you said, you could make payments for the person or their kids. The kids are definitely other beneficiaries, but if it says you can make payments to others for services provided to them, I don't think that's going to be a problem.
Right. And they're going to be looking at the terms of the trust to make the decision, not the accounting of the trust.
Okay, so if you inherited an IRA prior to 2019, do you go by the old rules for RMD and lifetime distributions?
Yes.
Good. That's a good short answer. Okay. Your firm wrote a special needs trust for my son with manic depression. Now my son has become the father of 2 autistic children, so how do I protect them? Also, I wish to protect the money in case of divorce. What should I do?
So the trust should already do that, the second part, the divorce part. But in terms of, so I guess one question is his children the remainder beneficiaries on that trust, or does the trust continue for the benefit? But they're also disabled, so in fact we have a trust for 3 people who are all qualified as eligible designated beneficiaries. Is that okay?
Yes, yeah. So I think that we would want to review the trust, because part of the reason that we wanted to do this webinar was to sort of raise these issues with the public and also primarily our clients, to make sure that we review trust to see if any of these provisions are in there. For example, a provision to allow for distributions to descendants. And in this case, it would be okay because, well, it wouldn't necessarily, because there could be descendants that were not disabled, but we want to review the trust as the bottom line to see if there's anything we should take out for purposes of retirement planning. And assuming the trust is for the sole benefit of the disabled individual, it can continue to be for the sole benefit of the 2 autistic children. They could qualify as eligible designated beneficiaries too.
Okay, so just lastly, we will have a copy of this presentation, a recording of it. I can also send the slide presentation in the follow-up email, so be on the lookout from us in the next week or so. That is all the time. I think we went a little bit over, but hopefully we answered everybody's questions. If you do have additional questions, you can contact the firm at margolis.com. You can also ask questions on askharry.info. So that's another great resource. And thank you to Harry and Tricia. And with that, I hope you have a great day. Thank you.